I'm very happy to follow on from my colleague Trevor Mallard, who, amongst other things, in his very useful contribution, established for the House that he is very, very old. And I want to thank him for that. Of course, as we debate Part 1, the definitions section of this bill, and I've got a number of points that I want to raise on the definitions, it's useful, of course, to remember why we are here and how this whole debate came about. And it came about because the GCSB, the agency, one of the agencies whose powers are significantly increased under this bill, was unable to read its own act, to interpret the law as it stood. They were unable to do that, and this bill expands their powers. So they weren't able to stick within the law as it was. So the government's solution to them being unable to follow the law as it was is to increase their scope under law. And there are a number of reasons why the definitions section in this bill creates some huge concerns in that regard. Now, of course, there's a little irony in all of this, that the catalyst for this, the best example of the GCSB being unable to follow its own law, was the Kim.com case. Now, of course, who was Kim.com? He was John Banks' big donor. And, of course, John Banks lost his job today because of those brown bag anonymous donations. Well, it's absolutely relevant, Mr. Chair, and I'm intending to come back to. I'm intending to come back to it because I'm going to come to the definition. I'm going to come to the definition of national security because it is directly relevant to the Kim.com case. Absolutely relevant to the Kim.com case. So national security, according to this legislation, says in relation to New Zealand, it includes economic well-being. How much broader could a definition of national security get than simply being economic well-being? This bill gives the minister enormous powers on the basis simply of the country's economic well-being. Doesn't necessarily need to suggest that anyone's broken a law or that any operator has broken a law, simply that the minister deems it to be in the interests of national security. So in the Kim.com case, Kim.com, Mega, may not have even been deemed to have broken any laws. It simply could have been the case that the minister decided it wasn't in the country's economic well-being for the mega operation to continue to operate. This is my understanding of how this bill operates, and I'm sure my colleague Claire Curran will correct me if I'm wrong. But my understanding of it is under this definition of national security, which is purely economic well-being, the minister could effectively shut down mega if she deemed it to be not in the country's economic interest, to do with economic well-being. Nothing to do with whether any laws had been broken, simply it applies an economic well-being test. That is so utterly broad. Now, Amy Adams is shaking her head, so I'm hoping that she will address this issue when she makes her contribution in this part of the debate, because I have never seen anything which defines national security and extends national security powers so broadly, and yet has such a broad definition of what national security actually is. And I think that that's incredibly concerning, and I'm looking forward to the minister's contribution on that. Coming back to network operator and the definition of network operator, another question that I have for the minister is whether the government's network for learning, the network for learning that's being extended to all schools in the country and made available to all schools, whether that would come under the definition of a network operator. So does the government now become, and Claire Curran has just passed me the information, some further information about the network for learning, although I'm relatively familiar with it. We've got 21 schools, according to Nikki Kay, being connected to the network for learning by the end of this year. And I actually would quite like to hear from the Associate Minister of Education, who is overseeing the implementation of the network for learning. She's on the phone, so I'm assuming that means that she's getting some advice on this matter so that she can participate fully in this debate, because I would like to know what the implications of this bill are for the network for learning. It's going to be rolled out, from what we understand, to all schools in the country over time. It's a significant network. So let's look at what the network operator definition in the Act states. The network operator means a person who owns, controls or operates a public telecommunications network. Now, the network for learning surely must come under the definition of that. So what are the implications? That, this is a managed network for schools that's going to connect schools together via a secure data network, offering high levels of service quality and support. So the government here therefore become a network operator under the definitions of this bill. And so what are the implications for the network for learning and for interactions with kids who might be using the network for learning as a result of this? Are the GCSB now, as a result of this legislation, going to be snooping on kids and teachers throughout the country as a result of this legislation, because under the definition of a network, under the definition of a network operator, the network for learning could well come within that definition. Mr. Chair, I can see that I've run out of time, but I'm calling again, Mr. Chair, even if you're not quite ready for me, Mr. Chair.
I'm calling Chris Hipkins.
Thank you very much, Mr. Chair. So let's look at a network security risk. Network security risk means any actual or potential security risk arising from the design, build or operation of a public telecommunications network, any interconnection to or between public telecommunications networks in New Zealand or with telecommunications networks overseas. So that's, again, it's a very, very broad definition. Any actual or potential security risk arising from those things. So could kids working in schools be deemed to be a potential security risk? And could, on the basis of that, we have the GCSB snooping in on the activities of schools and kids as a result of this legislation? And I think we do want to have some clarity. One of the problems with this bill is that the definitions are simply so broad. Now, I'm completely willing to admit that I wasn't part of the select committee process for this bill. I've picked up this bill this afternoon for the first time and tried to make head or tail of it. I have to say it's incredibly complex, incredibly difficult, but I have been alarmed in the reading of the definitions at just how broad they are, and when we get into Part 2 in particular, just how sweeping the powers under Part 2 are. And the reason that, of course, the Part 2 powers are relevant to the debate on Part 1 is the Part 2 powers all rely on the definitions that are established here in Part 1, those very, very broad definitions. Let's look at the lawful interception authority. So that means an authority to access an information infrastructure within the meaning of the Government's Communications Security Bureau Act 2003. Includes an authority to intercept a private communication, whether in an emergency situation or otherwise, that is granted to any member of a surveillance agency under any other enactment. So, authority to access an information infrastructure. And what is an information infrastructure? So let's go back and see what the definition of an information infrastructure is under this piece of legislation here. An information, it's not defined. An information infrastructure is not defined. So basically, we've got here, unless I might have missed it, but no, I can't see it here. So we've got here, this gives, we've got it, I'm sure she will, means an authority to access an information infrastructure. Well, what is an information infrastructure? How can we be having a definition with another definition contained within it that isn't then defined? It actually just makes a mockery of the whole thing. This bill is so poorly worded and gives such broad powers it is almost certain going to result in significant legal challenges to the government. And the reason that all of the New Zealand public should be concerned about that is because it deals with such a sensitive, delicate issue. It deals with the privacy of New Zealanders' information and their interactions online and using other forms of telecommunications. I said in earlier debates on this matter that I think the issues around privacy and around what New Zealanders can expect when they're using information communication technology is going to be one of the biggest and most challenging issues that this Parliament is going to deal with over the next few years. And what we've seen from this government is that they deal with this debate in an ad hoc, piecemeal fashion without a real, proper, thorough examination of the principles that should guide that, and that's why we end up with bad legislation like this. For example, if we turn to the principles section in the Act, in Part 1 here, so I'll get to the principles section as I was reading it a moment ago. Clause 5 here, the purposes and principles. We've got principles relating to an interception capability. We've got principles relating to network security, but there are no principles relating to privacy or no principles relating to the actual New Zealand citizens' rights under this legislation. And so surely in a principles section, which Part 1 of this sets out the principles behind the Act, surely we should set out the principles under which the powers being granted by this bill should be allowed to be used. And one of those principles has to be a balancing principle that protects the privacy of New Zealanders, and yet that is not in here. And fundamentally, when we debate this legislation, Claire Curran has mentioned this, and you'll find, the House will find references to it in the Labour Party's minority report, we have to get the balance between privacy and security right. because a democratic system relies on both of those things. This bill basically says that the government can ride roughshod over individual rights and freedoms in the name of security, adopting an incredibly broad definition of security, it's massively expanding powers, and it is not democratic, it is not fair, and it is not right.
Call Stephen Browning.
Thank you, Mr. Speaker.